All right, hi, welcome back. Attorney Steve Vondran, welcome to another exciting episode of Litigation Whiteboard, or should we call it Trademark College? Attorney Steve's Trademark College. Got lots of great trademark videos on my page. Check out the playlist, see if you find something that is of interest to you. Today, we're talking about trademark expungement. What do you do when you want this trademark? You got the perfect name for your company. You're all ready to just get rolling. You want to invest in your advertisements and your website. You want to do all this. And you find out somebody's already got your trademark, a federally registered trademark. Oh man, this caused problems. Or does it? Without further ado, let's head to the Attorney Steve Litigation Whiteboard. All right, today, here we go. Ex parte means by yourself or by the use of the director of the United States Patent and Trademark Office, right there, USPTO, Patent and Trademark Office. So let's say I've got this name for Vondran Legal. I'm over here. I got a trademark. I registered it for Von Deasy, Law Made Easy. Yes, that sounds good, doesn't it? And I put in my trademark application that I'm going to provide under this trademark bar review services. I'm going to sell shirts and t-shirts and mugs and all kinds of stuff. Also, and provide legal services. So maybe I'm in a couple different what we call classifications or categories. I'm in Section 8, 25, and 31. So when I filed this application, I'm telling the USPTO that I'm actually using this mark in commerce, in interstate commerce. That means United States wide, which usually means you have a website and you're offering it to sale across the country, across the world even, okay? So federal trademarks require interstate commerce. You can get state trademarks. For example, you can go to California, Arizona, two states where I practice. You can go just get a state registration. If you just have a donut shop and you're just doing nothing but donut, or hair salon and you're just doing that in your state only, you can just get a state trademark. But a lot of people like that federal trademark, nationwide protection, and some other benefits. You can block imports and things like that. But say somebody down here, my competitor, I have lots of competitors. Everybody wants to take on Attorney Steve, everyone. So say somebody wants Von Deasy. They say, I want to register Von Deasy, but I went and looked. This guy, Vondran Legal, Steve Vondran, he already owns the mark. Or another scenario is they applied for Von Deasy only to find out that they received what's called an office action letter from the USPTO examiner. There's an examiner file assigned to your case over here. And they said, well, you can't get a Von Deasy. Somebody's already got it. But then you go and you look and you say, well, Von Deasy is not, they're not using it. Vondran Legal is not using Von Deasy. Trademarks, I thought Attorney Steve said trademarks are based on use. They haven't used it. They've never used it. So in these expungement cases, these are what we call never used cases. You have to show that the other party never used the trademark. And if you can do that, here's what happens, okay? First, there is a time frame to file these. It must be within the 3rd to 10th year of registration of the mark. So if I'm 3 years in, 5 years in, 8 years in, 10 years in, great, you have a right to file this to challenge my trademark and get it expunged. Say that simply he's not using it. He shouldn't have it. So this is a way you get the office action letter saying there's a likelihood of consumer confusion because there's somebody there already. This may be something you need to do. File a petition to expunge. And this is very simple. So you must be within the proper time frame. You file the petition, and your burden, the initial burden, is on you, the challenging party, to show the USPTO examiner that there is a prima facie case of non-use, that you can show the reliable evidence, okay, websites, screenshots, Wayback Machine, show sales sites, things like that. Anything you can find, regulatory filings, anything to show that they're not actually using the mark. Go to their domain. Are they actually using it? Are they using these things that they talked about? Bar review, shirts, legal services. Is it using all those, or are you using none of those? So you can challenge the entire mark, Von Deasy and everything in it, or you can just challenge a classification if you want. So you have a lot of options in what you need to do. Maybe I'm doing these things, but I'm not doing bar review. So you can get bar review canceled. This guy says, well, then let's do Vondran for bar review. I'll get the trademark. So that's how it works. So you have to come forward with the prima facie case. You show the evidence. Now, whenever you're submitting these, you need to have a proper index. Be very careful. You got to have those index nice and neat in your exhibits, and be very, very detailed. You need to lay it out. Make it look nice and easy. Here, follow the trail. They are not using their mark. They have not used their mark. Or things like maybe there's a nominal use, what we call de minimis, or token, a token use. Well, I mentioned it here or something. Not real use, not a bona fide use as we're talking about. Maybe the use is only in intrastate commerce. Maybe it's only in California. Maybe it's only in Texas or Florida, New York. So you point that out. There's no interstate commerce. You have to have the interstate commerce. So these are things you can point out: fraudulent specimens, fraudulent use, doctored specimens. Maybe they look at the specimen that Vondran filed when they got the trademark. What did they submit to the USPTO? Or is that what they're using? So you got to look at these things, put together a detailed case. You're looking at paying $400 a class to do this. Once again, you can expunge the mark, a class, or certain goods or services in that class. So you've got a lot of leeway. And if the USPTO feels that you have met your burden, they will institute the proceeding. We call this director initiated. So they will initiate it. You can even file these anonymously, so the other party doesn't know who you are. They don't get mad at you. It's up to you. But these can proceed anonymously. So then the burden's going to shift. They're going to contact the registrant. They're going to say, hey, Vondran Legal, you own Vondran. You're not using it. This party says you're not using it. They want to expunge your trademark. It's my burden to come back and say, whoa, ho, 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 ho. Vondran, law made easy. I am using this here. I'm using it here. I'm using it there and everywhere. So that's what happens. They decide if the mark is being used, they're going to get Vondran will keep my mark. If not being used, expunged. Bye-bye. Free for registration here. So that's the real basic of how these proceed. In expunging, just remember, these are what we call never used cases. You have to show that it was never used. You have the strict timeline. If you're outside of 10 years, they've had the mark for 15 years, you're not going to be able to do this. Now, I have up here only a couple other things. This is known as deadwood. Deadwood on the register. They don't want deadwood, things that are they're not being used and so forth and so on. You also should compare and contrast this with re-examination proceedings, which I'm going to discuss in a separate video. Make sure to, boom, punch that like button, subscribe. And also compare this with the cancellation proceeding before the Trademark Trial and Appeals Board, TTAB as we call it. So that's right here, the TTAB cancellation proceeding. So if you have a case where they have used the mark, but maybe they abandoned the mark, or you're outside these time frames, you may need to look at the cancellation proceeding. Now, a problem with the cancellation proceeding is it can be more costly. It can be like a mini trial. The other party may contest it. So you may have like a contested action where you're really doing a lot of work and actually having like a trial. So you're really doing a lot of work and a lot of costs. So compare and contrast that with this new process, which was created under the Trademark Modernization Act of 2020. That's what created all this. So make sure you bookmark me. This is General Legal Overview. Yes, you can cancel somebody else's mark. If somebody's not using it, you want it, you can prove it, then you can get into one of these proceedings, okay? Compare and contrast that with the TTAB, cancellation proceeding, and the re-examination proceedings. All right, guys, that's all I have for today. This is general legal information only, not legal advice. Don't rely on this. Just digest it. It's a good stuff. All right. Have a great day. Attorney Steve. Gotta run. Bye now.